Good morning, everyone. Good morning. I want to welcome you here to the Brookings Institution. I'm Camille Busette. I'm the Interim Vice President of Governance Studies. And before we get started, as you know, to pull off an event of this type and size, it always takes a lot of people. We have a tremendous team behind us in our development capacity, communications, our security, and our catering teams. And I just want to recognize them before we get started. So welcome to the launch of our new Katzmann Initiatives on improving interbranch relations and government. The Katzman Initiative is named after Robert Katzmann, a lawyer and political scientist who worked in this very building from 1981 to 1999, the year in which he was appointed to the U.S. Court of Appeals for the Second Circuit. The three main pillars of the Katzman Initiative are topics to which Bob Katzmann devoted his energies here at Brookings and in his role as a federal judge: promoting effective interbranch relations, monitoring the health of our democracy, and promoting civic education. A timely set of contributions for a trying time in American history. We are fortunate to have well-known presidency scholar Katie Dunn-Tempest serve as the director of this new initiative. Under her leadership, the Katzman Initiative has grown from a mere idea to a thriving effort generating compelling research. The new Courts Congress dashboard, which charts the relationship of these two branches of government over time, was just released and will serve as a lasting resource to students, scholars, and citizens across the country seeking to learn about this critical relationship. I encourage you to check it out on our Brookings website. I look forward to its future contributions that will shape and expand our understanding of American government. Of course, today we honor Bob Katzmann's intellectual and professional legacy. But beyond that, we are also honoring a husband, a brother, and a friend who touched so many in indelible and lasting ways. As you know, today we are also very honored to have Justice Stephen Breyer with us to celebrate this initiative. Justice Breyer and Judge Katzmann were friends and colleagues, and Bob's brother, Judge Gary Katzmann, who is here today, was one of then Judge Breyer's first law clerks in 1980. Justice Breyer has a long history with Brookings going back almost 50 years. As chief counsel to the Senate Judiciary Committee, and later as a circuit judge and as a member of the U.S. Sentencing Commission, he participated in the so-called Williamsburg seminars, annual conferences launched in 1978, sponsored by Brookings, the federal courts, the Judiciary Committees of the House and Senate, and the Department of Justice, to allow off-the-record exchanges between judges, legislators, and executive branch officials. Since his 1994 appointment to the Supreme Court, he has appeared on this stage several times, and earlier this year, Brookings hosted the 10th lecture in the Justice Stephen Breyer Lecture Series on International Law. It is with great pleasure that I welcome Justice Breyer back to Brookings. Justice Breyer will tell us a little bit about his friend Bob Katzmann, and he will also be joined by Brian Richardson, who I'd like to welcome, a former law clerk to both Judge Katzmann and Justice Breyer, and currently a professor at Cornell Law School. Brian will ask his former boss, Justice Breyer, incisive questions about his new book, Reading the Constitution, and thereafter we'll open the discussion to you with Q&A. Again, welcome and enjoy.
No, you don't know. You're not old enough. You're not old enough. This is Old Home Week. I mean, look, I was here before, the earliest point you mentioned. No, we had, what's new? Well, you painted the place. Really? We met down, who's we? There was something called the regulatory group. It was Charlie Schultz, Dick Caves was there, George Eads, and it was connected with AEI. It was Chris DeMuth. And we'd meet down here, and Caves would say, why do they force a grandmother who flies from Boston to Los Angeles to see her children to pay more so that the business traveler from New York to Utica can pay less? That was the beginning of airline dereg. Airline dereg. I had something to do with that. We all did. We all did. That was Brookings, AEI, and a lot of others beside. And with the truth of the airline dereg, what was the truth of it? The fares are now half, in real terms. They really are. And it was Andy DeBorny. I look around and say, where is George Eads now? I don't know. Jim Miller was involved in that. We were all involved in that. The whole government, the sensible part of the government, which was started at Brookings, you say. And the peeling paint off the yellow walls down in the basement. That's all right. Because Andy DeBorny told the truth about that when United Airlines tried to get out of it and made a whole lot of statements we didn't think were too accurate, so we flew out and we sort of caught them out on this, and this, we thought. And Eads said, or DeBorny said, well, Stephen, he really knew the industry. You are right. I think dereg is a good idea. You will bring people into the airplane who can't afford to fly. The fares will plummet, and they have. If you check it, which you will. The fares have plummeted. We'll fill up the airplanes, absolutely. People who have never flown will fly. And you, Stephen, will hate it. Yeah, right. Okay, that was the start at Brookings. It started what I taught, regulation and administrative law, and Stewart and I brought that in. Well, that was Brookings, and Brookings with a lot of other things after, which you mentioned. Strobe was a great friend, and goodness. So I don't know if I'll just say anything. I'll just wallow in nostalgia. and Gary, and my first law clerk, and his brother, I couldn't tell them apart, twins. And Bob was great. And I used to think sometimes, at least intellectually speaking, they think they have twins. I think it's triplets. Because, well, what? I mean, my goodness, we did see a lot. Russ Wheeler, came down here, and we were trying to deal with the ethics problems in courts, and we did. Sally and Russ, and we were always going down to Williamsburg and heard Strom Thurmond say, you know, he said, when you worked at the Judiciary Committee, we usually work things out. He's speaking to me and his staff people and probably to Kennedy. We usually work, but we can't today. He says they're all upset about abortion. I took that in. They're upset about things we can't compromise on. We don't know what to do. That was Thurmond. Interesting. And we had all kinds of things going, and you repainted the walls and to make it look better. No, it was great. It was great. And AEI, too. I'm sorry they split off on this regulatory thing. I'm sorry they did. Because it was so interesting. Now, well, Bob, why do I say twins? I read his book on interpreting statutes. So I wrote one like it, word for word. And I read, and it wasn't so easy. You know, it's easy to say what we're going to do. When he worked with Frank Coffin, as Chief Judge of the First Circuit then, and they were trying to do little, I say little because they were non-controversial things where the statute wasn't drafted correctly. So why don't we send some information over to the Judiciary Committee? They could redraft them. And why it was difficult is because I've always thought, since I worked in the Senate on the staff, there are different time frames. Harold Wilson was right when he said a day is a long time in politics. And over in the Senate Judiciary Committee, it seemed like a minute was a long time. That's just not the time frame judges are on. Over in the court, they're in a time frame of 2 or 3 months, looking out to several years. But they're going to do their work in 2 or 3 months. So it doesn't work. I remember one day I was sitting there, I got a call, it was from Warren Burger. Well, why was he calling me? That was the first thing I thought. I mean, I'm not Senator Kennedy. I'm a staff person. And then I worked out why. No one else would talk to him. And it wasn't because they didn't like him. I think it was because no one had the time. After all, what politics is, and I use this as an example all the time, politics is Senator Kennedy gets a call from the mayor of Worcester and instantaneously from the Secretary of Defense. Which will he answer first? That's about the easiest question under the sun. I mean, of course the mayor of Worcester. They're constituents. I see a young woman in my office and she's going through every single paper on my desk. I get a little annoyed. Who are you? I said. How are you here? Well, I'm a student and I wanted to see what you did over in the Judiciary Committee. So I said, you're going through all my papers? Yeah, yeah. I said, so I was a little annoyed. But then just before I sort of expressed my annoyance, I thought, maybe she's a constituent. Yeah. Right. You understand how that place works. And that's not the court. Absolutely not. And so Gary had, and Bob on this one, had his work cut out for him there with Russ and with other people to try to get some kind of communication going. And I think they achieved something there. And of course, Bob was alpha on immigration and to see that people had lawyers. That's good. The judge doesn't just sit there and say, hey, where's your lawyer? If there are no lawyers around, and if there's no way to get representation, maybe he tries to do something about it. And that, I think, is what is at the basis of this thing. When you see a problem, and it's within the range of things that you can do something about, do you try to do it? And the answer to Bob was always, 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 yes. Absolutely. Yes. And what did we both think? And Sandra O'Connor thought that. And Tony Kennedy and David Souter and all of us, really. How are we going to improve the good old USA? We're going to improve it by teaching the high school students something about civics. And they went out in different ways. And there is a thing up in the First Circuit where they bring the students in. And there is a thing in the Second Circuit. And I remember hearing him talk about that. So I, of course, look at his opinions. Of course, I would see what he was doing there. And it was called improvement, improvement. That's not an outdated idea. That's an idea we actually can work with. And that's an idea he spent his life working at. So we say, thank you, Bob. And I think maybe I could be an honorary triplet. That's the thing. All right, now we want to talk about this book. Why did you write the book? So I could go around talking about it. Why not? But how do we do this? What do you want to do? You want my former clerk, Brian Richardson? Where do I go? Over here? I think so, yeah. Okay. Oh, here? Okay.
It's the cameras.
See, we've moved from what do you call it, norms and approaches to rules. And one of the rules is I sit on this side of the
Exactly. Good morning, everyone. I'm delighted to be here. My name is Brian Richardson. I'm from Cornell Law School, and I had the honor of clerking for Chief Judge Katzmann and the man to my left, Justice Breyer. The man needs no introduction, but as you know, Justice Breyer is the Byrne Professor at Harvard Law School, where he has long served on the faculty, and perhaps the least retired Justice of the Supreme Court. You're extremely busy these days. Before we dive in, I have two logistical announcements from the organizers. The first, please remain seated when we finish today. We will run about 55 minutes, and then we will throw the floor open to questions from the audience. So think through your questions in advance. And in connection with that, a reminder, both for myself and for the group, Justice Breyer cannot answer questions about pending cases or controversies at the court. I mean, we can try asking them, but we are hoping, apologies, Justice, to ask you as many questions as possible. So in the interest of doing that, please keep that admonition in mind. So without further ado, Justice, as you know, we have two goals today. The first is the launch of the Katzman Initiative, which we've heard a bit about. The Katzman Initiative has three pillars, which we've actually just heard about in your remarks. The first is the relationship between courts and Congress. The second, examining that relationship. The second is monitoring the health of the three branches. And the third is the promotion of civic education. And our second goal is to talk about your wonderful new book. And happily, I think, those goals converge. So before today's event, we asked the public for a number of questions. We have a few dozen, which we've boiled down. And the KI board has given a few questions as well. And they all sound in both the Katzman Initiative goals and your book. So I will talk through these two things. Last logistical announcement, Justice Breyer's book is available in the bookshop here at Brookings. And I discovered on the drive down from Ithaca is available as an audiobook that you have narrated if you would like to listen to it. All right, so one of the three pillars of the Katzman Initiative is examining the health of our institutions. You remind us in your new book that in order to perform their constitutional functions, courts need public support. You describe a number of important practices that our court uses to encourage compromise and moderation. I think some are collegial, order of speaking, those sorts of things. Others are institutional imperatives you've described in your book, rulings that are workable over time, that are accepted by an informed public. Could we start there? Could you tell us more about what practices make our institutions healthy? Question mark.
If you're talking, the best advice, which you well know, when we started on the staff in Kennedy's office, one of the things he told his staff, and I say this, and I'll say it in the same way I speak to high school students about, because they will, when I talk to high school students, which I like to do, the first thing they'll say, well, what should we do about this mess? I have an idea what they're referring to. Okay, so I said, why do you ask me? I say, it's your country. It's your Constitution. And you're the ones who are going to have to figure it out, not me. And so I hope you do. And when I speak to, this is what I'm talking to them. I speak to graduating class. I say, what can I tell you? I can tell you that I hope you find someone to love. I hope that you have a good job. And I hope that you work in public affairs. I mean, you just vote. That's good. And you can be on the library commission, or you can do a lot of different things. But there I draw on some experience, because I think John Adams, and I think anyone on the court and people who work with this document will think that this document won't work unless you participate in public life. And if they're really interested, I'll tell them, and I don't know if it's true what he said, but Derek Bach, in one of his books on education, wrote that, you can look it up, and I don't know, is it true? He said Pericles, in his famous funeral oration, extolling the virtues of Athens, said, what do we say in Athens about the man who does not participate in public affairs? We do not say he is a man who minds his own business. We say he is a man who has no business here. That's tough, but they're interested. They're interested, those students. So I say that's, yeah. And I want you to know what Kennedy did tell his staff. Very soon after they started working for him, he said, stop worrying about credit. He said, if you're successful at something, there'll be plenty of credit, don't worry. And if you're not, who wants it? But it is a weapon. And I'll pass on to you, I'm talking to the class, what he told us. He said, we're having a roadblock here on something. We want to get something or stop something or do something, and there are a few others and working for other senators, and they don't want to do it. Okay, here's what you do. You go talk to them. Find someone. That's what Mills said. I don't know if that really did say it, but I think he did. Find someone intelligent, you respect his opinion, and he doesn't agree with you. Go talk to him. See what she says. Okay? Wait. Don't talk too much. Listen. And if you listen for long enough, what will you discover? That person, that man or that woman that you're talking to actually says something you actually agree with. And as soon as that happens, you say, what a good idea you have. Mm-hmm. Right. Let's see if we can work with that. And lo and behold, you may get somewhere. You may get 30%. Take 30%, please. Do not hold out for 100% because you know your followers will say how wonderful, what a principled person you are, how great you are to have really wanted this whole thing, and too bad we went down the drain, but we were principled. No. We want the 30%. You take that 30% for real. And then when we get it, we have something. And how often I've heard him, quite often, questioned by press when we did get something. Senator Kennedy, you did such a good job on that. Don't thank me. Thank Orrin Hatch. Thank the Republicans for having come up with an idea that brought us down. I saw that for 4 years. I worked for him, 2 on airline direct and 2 on chief counsel. All right. So I saw that in operation. Not 100%. I mean, you can't stay in Congress and be 100%. but quite a lot. Quite a lot. And I said the important thing is you get something done, go out and talk to people. Now, what I found interesting in that little thing with my imaginary high school students, which often is not imaginary, not what I said, but rather they're interested. They're interested. You can tell, I think, maybe I'm making it up, but it's the look in their eye, it's the silence in the room. They want to hear it. And they want to hear it because they want to do something. And now we've given them something to do. And not only have we given them something to do, we've given them something to do that might get them somewhere and get the country somewhere as a result, You see where I'm going? Okay. So I'm not totally pessimistic. And you've led me into something that explains why I'm not.
So before this event, one of the KI board members noticed not everyone goes to the State of the Union address, but you do every year. And he asked why.
Why?
Yes.
So people know that there's such a thing called the judiciary of the United States. I mean when they get off their screens, the younger ones, which they do get off their screens, contrary to popular belief. I've seen it with my own grandchildren. They do get off their screens approximately 14 minutes a day. And they should actually, know that they don't know what's being said, or they might. But they're going to see Congress, they're going to see the President of the United States, and I would like them to see the judges too. We are called the third branch, and we are a branch of the United States, and we are a nation that is built on rule of law. All that's there, and they'll take it in visually. Because sometimes I say to my grandchildren, have you learned how to read? Or did you just go and play games on the screen? I guess I'm the only one in this room affected by that problem. but yeah, okay. So of course we should go. And well, that was not uniform in the court because it comes at a time when it's in between our sitting in January and the sitting in February, and some people didn't want to go, and other people thought, well, we shouldn't because it's too political, and it is political. You know, first one say, and the other side say, All right. We know that it is very political, and some of the justices thought. So I just said, when I think it was pretty uniform not going, I said, I'm going. I was pretty brave. If you're there long enough, you get those occasions when you can say, that's what I'm going to do. That's not a good habit, usually. But nonetheless, I said I was going, so. Person in charge said, well, you can sit up in the balcony. I said, no. And so they organized it, and I did go. I didn't go once because I had 104 temperature or something. But I went for a period of time, and gradually they came back. Gradually they came back. And I think that's very good. And I hope that continues into the future, and I think it will. And so just use that, if you want, as a little marker of something, that in the Supreme Court, time matters. It's a long time. New appointments were made recently. Justice Douglas said 5 years. David thought 3 years. It's a long time. And you become more used to it, and a few other things. I don't want to go on.
That's great. Well, you are, I think, an optimist about our future. I'm just taking your lead from a moment ago. Your account of the court's work over the history that you describe in the closing chapters of your book expects that the court will find, you're right, it will find the necessary general support from the American public as our constitutional history unfolds in the future. And this question came, I think, from 4 folks in the audience. How would you respond to uncertainty or even fear about the effects of increasing polarization in our democracy? And relatedly, how do you think the court could ensure that it will continue to find that support in the American public as people get their news from things like social media or less reliable sources?
Don't know.
Don't know.
I don't know. We've had, go back to my own experience. I mean, some of you were around at the time of Vietnam. You don't know that I had to spend the night in Widener Library with Archie Cox because the students were going to burn it down. And I would say, but I didn't cause Vietnam. I'm not even for it. And that made no difference. So Abe Shays had the bright idea of getting buses for these students, and we got buses for them, and we sent them down here because of the March on the Pentagon. Perfect. They liked it. We liked it. They're out of our house. So there were a lot of bad things that happened. If you haven't seen it, and I bet everybody in this room has seen it, you turn on YouTube and you get Bobby Kennedy's speech in Indianapolis. My God. I mean, the day Martin Luther King was killed. And the governor of Indiana said, don't do it. It's a poor neighborhood. It's a primarily black neighborhood, and you don't know how they'll react as they hear this news. Bobby said, I'm going. And he sat there on the platform, and he quoted Aeschylus. His father made them all apparently learn some of Aeschylus, and it was about the pain dripping, I can't do it. And then you think to yourself, it was something about trying, holding us together. And you think, 3 or 4 years ago, his brother was killed. 4 weeks, I think, from them, he will be killed. Martin Luther King was killed that very day. A significant number of students were killed at Kent State and elsewhere. Watts was burned down. There were plans Jim Varenberg had to be on the committee to try to stop him from burning down Washington. All kinds of different people. And when the soldiers would come back, if you want to watch something that moved me, because of course I was rather hostile to the Vietnam War, but the soldiers would come back and these groups of people would go and throw things at them and hiss and boo, and Ken Burns made an awfully good series of the Vietnam War. And one of the things in that moved me was a woman who was a big demonstrator at the time. She got she was talking to Ken Burns, and she burst into tears. And she said, I'm sorry. I'm so sorry. And she was. And what she meant was they weren't at fault, those soldiers. They weren't at fault. And that's what she was sorry about. You see, so we've lived through some tough, tough times. That was one. Civil War wasn't exactly, slavery, Jim Crow. I mean, that's another Kennedy. The country goes like this. All know Winston Churchill, U.S. government, U.S. of A always does the right thing after trying everything else. Yeah, okay. So it's the high school students. That's where he's so right, Bob. It's the high school students you have to explain all that to. You say, something else in Cambridge, Massachusetts, which when COVID was there were groups of people, ordinary citizens, who went around to see that all the old people were fed and that they weren't sick. And that happened probably in San Diego and St. Louis, across the country. And my fifth grade teacher, Mrs. Squataguatza, I liked her, but she'd have projects about the government of San Francisco and 4 students assigned to each, okay? And 1 grade. Hey, you learn how to work with other people under those circumstances. And we're supposed to be good at that. Americans are supposed to be good at that. There are all kinds of projects, all kinds. And get together on this, get together on that, forget about this one. Okay, do that one. But we're not bad at that, I like to think. And see, all those things, I think, sure. And then you want to go personal, you say, what is it? the Supreme Court. What is it like? Why does it take 5 years? Should I go into that?
Please.
Okay. Why, I think, this is just my view. First few years, you're frightened. My God, I thought I could take this job. I thought I could handle it. I told all my friends I could. I wanted to get appointed. And there I am. Oh, my God. Can I really do it? I mean, can I really do it decently? Because often a lot depends. And maybe you sit around and think, I can try. And it's only after 3 or 4 or 5 years that you say, okay, I may not do it perfectly, but I can do my best at it. Pay attention. And really, the thing that's hardest to take in, and you never know if you're taking it in completely, it's what a president told me. He said, the applause dies away faster than you think. Very fast. And he said, then you have the job, and you better like it. You better like it. And boy, that's true. I mean, after 2 years, I'm in some reception, and there's a young law student, and he says, Justice Breyer, you write such wonderful opinions. I would love to have your autograph on my program. Can I have that? So I said, sure, of course. So, now, he turns away, and as he turns away, he talks to his friend next to him, and he says, that makes 4. I understand. And so what is there about this job? It's like the doctor. You have to pay attention. God, I see you here. Ruth did. I mean, she really did. I'd go into her office when I'm allowed in her office. She doesn't have to say anything. I know I can walk in anytime. We can talk. It's only when she starts to get up and go to her stand-in desk, which she would, because she's going to get that opinion written. And so I better calm down with my jokes and go down and get my own written. And yeah, it was good. I enjoyed that a lot. It was great. But because you have to pay attention. And it's, as I say, the reason I compare it to a doctor, and if you read Le Peste, Camus, you'll see in the last paragraph, it's there. The reason that I do is because a doctor never says, oh, this patient has disease X, I've seen it 1,000 times, so I won't pay attention. No doctor does that. No one. And no judge really does. It maybe seemed minor. Maybe it was a question of the comma. What is the meaning of that after internal revenue go da, 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 da? Does the word for, which is the next word, mean a which or a that? We had a case like that. I liked it. I don't know if anybody else did. Or Ruth may have liked it. That's true. But you pay attention. And you give what you have. And that's the virtue of the job as you get older. The opportunity to do that. And so that's why I say things calm down. You begin to see how things worked out. Douglas thought it begins to repeat, not directly repeat, but somewhat repeat in the subject matter and so forth after 3 years. And there are rules that help to bring us together, informal rules. In the conference, nobody speaks twice till everybody speaks once. I was junior justice for 11 years. That meant I spoke last, so it did benefit me. And I almost got the world's record. Alito was sworn in 11 days before I would have had the world's record for being. You realize, I thought of writing him and saying, just wait 11 days. You see, and then I could go down in history as the answer to a trivia question. Fabulous. But no one speaks twice. And it's very serious. And I've never heard a word in that conference shouting or angry about somebody else or saying mean things about somebody else, even not even as a joke. Professional. Go around. And I also learned, listen to what people say. As soon as I get there and I start in the temptation of, I have a better argument than you, ha, 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 whatever form that takes, that leads the other person to say, I have a better argument than you. That gets us nowhere. And so try. Nino thought we didn't often get somewhere. I thought we did. You try. You're not going to get perfection. You're not necessarily, sometimes, actually switch people, but you might. It matters a lot, those words on the paper, and how you approach the problem. What you say is important, what you say isn't, how you deal with subsidiary things or other things, all that's important. And you want to bring people together. And they'll work like mad, they will, to get at least 5. 9? Good. That's better. 40% used to be unanimous anyway. I think they probably still are. 40%. What used to be 5 4s, 5%, 10, 15, sometimes 20. Not always the same people. I counted it one year. There were 18, I think, 5 4s. And of those, 12 were not what we might call the usual suspects. But I thought to myself, I didn't look it up. You can if you want, but I thought to myself, every one of those 12, not the usual suspects, the press is going to say, in an unusual combination.
That's right.
Okay? So, over time, when some things don't work too well, I wrote this book in part to show some that wouldn't work too well. They'll learn. Now, not everybody's going to come out the same way I do or whatever, but that's just, it's a big country, and that's not surprising, and so forth. But get along together, yeah. So I'm somewhat optimistic, but I don't know more than you. I mean, it's a problem for everybody, not just one for us.
Thank you. So one of the KI goals is examining the relationship between Congress and courts and the executive, the interbranch question. I note in your book, you describe a burning set of questions taken up by the court in recent terms, which is the role of agencies in our constitutional structure. You ask the question, you note that numerous students of the subject criticize agency performance, but you ask, compared to what? To Congress or to congressional staff taking on the task, to judges or judicial staff doing the same. And I wondered if I could take you back to your time in the Brookings basement, to the regulatory group, and ask, in light of perhaps this moment of increased skepticism about legislatures' accountability or the use of agencies, does the skeptical moment we have is there a skeptical moment? And if there is such a thing, does it accord with your own experience in government before your time at the judicial branch?
Well, there are two separate things involved there. One I call the big question. The big question, let's go back to the Liberty League. Herbert Hoover. And there was a traditional Republican view, through the Liberty League as one example, that federal government's too big, too much regulation. By the time Roosevelt comes along, the country is no longer going to believe that's bad, and power shifts to Washington. But they're still, under the surface, very traditionally, it's not some new form, I don't think, of more conservative Republican, Ronald Reagan, fine, okay. And they can debate more or less of that. And that's maybe somewhere buried on the court, but it's buried. And then there's the kind of thing the court decides, and that's, typical, all the time. This kind of case comes up under somewhat different forms. There is a statute. The statute gives power to an agency. The agency, either through a rulemaking proceeding or some other proceeding or through no proceeding, gets X, which could be one person or the appointed people or somebody in the basement. I found out Paul McAvoy, he was in this too. Paul McAvoy and I went to find out, how does the Federal Power Commission, that's the predecessor of FERC, they change the initials all the time, how do they really set rates? So there used to be a green building over here somewhere, it was a bilious green. It was the Federal Power Commission. And we went down, and it was Swidler, and I can't remember who the other one was, that ran it during those times, and we got permission to go down, and we went down to the GS 18, 17, 16, 15. We found in the basement Georgia Ladakis. She was a GS 12, I think, or 14. And she was the one, because everybody else just ratified what she did. And we said, how did you do it? How do you do it? How do you decide what is a reasonable rate? And she said, It's not easy. So, well, what do you do? She said, well, we look at other industries and see how they're doing. Well, what other industries? Well, grocery stores, she said. So you decide what the right rate of return for a natural gas pipeline is by looking at grocery stores. Yeah, she said they help. Trucks, okay. She named about 4 other industries. But that's how she did it, okay? So you use your judgment. We found out. That was I thought, my greatest discovery when I was working with Brookings was how the natural gas rate, and I had on my desk at that time the Phillips Petroleum case following down in Oklahoma, where there were people following how they were doing that, and they had stacks of paper. But McAvoy and I had really found out. It was Georgia Ladakis, okay? Yeah, you can. We wrote a book about it.
I see.
Our first book. It was a Brookings book, and you can still get it. It's number 2,876,932 on the Amazon list. but you can get it. But in any case, there is this question for Georgia Ladakis, for anyone else who does anything in any agency. Hey, here's the statute. Here's what you did. Does this statute allow you to do that? That comes up in 50 different forms. And the things that they argue about is how much weight do you give to the agency's decision that we have the authority to do it, and how much not. And what we used to say in Louis Jaffe's treatise, it says, there are many things. There are many things that we look at. We look at what's now put in capital letters. I wouldn't have put it in capital letters. Is this really a big deal thing he did? Is it going to destroy the country's economy, or is it going to improve? Is it economically wide and huge? And it's the kind of thing Congress would have decided itself. For example, in Packard, are you getting my ad law lecture? This is the thing in Packard, what can the NLRB have jurisdiction over foremen? That's a very important question at that time. Foremen are in every company. Just what about a newsboy? See, newsboy, the court says, listen to the NLRB. That's not such an important job. Foreman, that's a big deal. You see, that was one of the things. But you look at other things. What's the scope of the agency's mission? Is this a minor sort of administrative matter? Is this something that they spent a lot of time working on? Is it something that, on and on and on and on. That's the traditional thing. That's more what the court gets. Now, with the answer to the first question, I am a member of the Liberty League. I'm not anymore because I'm a judge, but now I hate regulation. Is that going to help you answer, or the opposite? Is that going to help you answer the second question? I doubt it. I doubt it. It might. I can't prove anything. But it might, but I doubt it. I think the courts are involved in the second question. And they think there are going to be easy ways to answer that. I've never found an easy way to answer that kind of question. This is just as different from, this is not necessarily gospel. I mean, this is just my own approach. 40 years, that counts for something. And you have to look at the agency itself. You have to look at what a customs officer does. You have to look at whether they've looked into it thoroughly. You have to look at, and then you will get an answer to the basic question. Do they have the authority to do this? And you have to keep in mind what Jerome P. Frank said. Because on the question as it's put in the opinions, it will say how much weight, how much deference do you pay to the agency? And Arthur Goldberg told me when I was his law clerk, that's a terrible word, deference. It doesn't mean anything. You have no idea. And Jerome Frank wrote a great thing saying he didn't do it in respect to agencies, but he did it in respect to the trial court decision of a matter of fact. He said, I thought I had finally found a case in which I would have said the trial court made a mistake, but knowing that I should defer to the trial court in light of his greater expertise, I will uphold it. I thought I'd found that case, but On closer inspection, I discover, like all the other cases where I uphold the trial court, I agree with the trial court anyway. Is it? Okay. So now you get a picture of the chaos that I think is the law. And that's what we work with. That's what we work with. And lots of different rules.
We received a number of audience questions about the subtitle of your book, Pragmatism as Against Textualism. In your recent book, a note for the benefit of the audience, you cite Judge Katzmann's Madison lecture for a list of tools the judiciary uses in interpreting statutes, the Congress's work product, to use Judge Katzmann's phrase. You also cite work on pragmatism for the point that any good legal interpretation turns on the proper identification of a law's purpose, followed by a decision about, quote, what outcome in the case would serve that purpose best. You've called your method pragmatic, perhaps in light of the chaos you've described. And you quote the ancients on your first page. It's better to show us rather than to tell us what your philosophy means. But the audience wants to know, if you had to encapsulate or define pragmatism for the audience today, how would you describe it?
No, I didn't make up the word pragmatism.
Right.
My publisher did. They wanted to put it in because it was short.
No, I didn't.
And I wanted to make clear, because Posner does this a lot. He talks about pragmatism. For me, and I believe for Posner too, it's not well, but pragmatism is, he doesn't mean, I don't mean, do what's good. No. American pragmatism is something special. Mm-hmm. That's Peirce and James and William Van Orman Quine. And it's that you look to a whole system, a system which has in it institutions, lawyers explaining to clients, rules of stare decisis so you don't overturn too much too fast, rules about, not exactly rules, maybe approaches, maybe standards, and sometimes they change them. In California used to have a perfectly good standard, don't drive faster than it's safe. And then somebody got to them and said you should have an absolute speed limit, 55 or 65, and don't use a standard. Oh, well, why not use standards? And all those things are in pragmatism. How does it actually, let me be more specific, which will be more clear. I'm looking at normally, say in the Supreme Court, courts of appeals, I'm looking at a statute. It has some words in it. Same thing is true of the Constitution, but it's more general, usually, not always. And how do I interpret those words? How do they apply? Not so much what do they mean, but do they apply here? Read them. That's the first thing. You read them. If it says vegetable, I know that's not a fish. And I will not say it's a fish, no matter how good it would be if you called a vegetable a fish. No, it's not. But very often those words don't give me the answer. And if they did, why is this case in the Supreme Court? Because we take cases, really almost all of them, are because lower court judges have come to different conclusions about the same question of federal law. Well, why did they? They're good judges if the words are so clear. 2 senators, 2 is 2. And that's it. It's not going to change. But a lot of other words, the freedom of speech, etc. Okay, so I read it. And when it doesn't quite give me the answer, I begin to look to things like, what's the purpose of these words in this statute or in the Constitution? What's the purpose? Somebody wrote it. They had something in mind. So let's go and read what the report wrote. It may not be. Maybe it was a joke, or maybe it was people fighting and I don't get much out of it because they're each trying to get there. A lot of things that could make that report less than totally useful. But there are a lot of things that make it totally useful. And there are other things you can look at to try to answer that question. Hearing testimony, all kinds of stuff, purposes and consequences. If the consequences are going to be terrible, hey, Congress doesn't usually try to make consequences terrible. I imagine there's debate on that, but no, I think they don't. I think they don't. And they want something good to happen. Somebody believes something good is going to happen. let's look at those consequences, and let's look at those values. I mean, what have we got here? A document that's filled with stuff. Some of it, of course, and some I've written on. It doesn't tell you too much about values. I mean, there's what's the clause? We wrote one on the tonnage clause. That was it. I have almost exclusively the only justice ever written on the tonnage clause, but Stone did, and it was a good opinion too. But anyway, others, the freedom of speech. Okay, what's there? Democracy, basic human rights, equality, rule of law, separation of powers. That's there. And how do we do it? Well, let's look at McCulloch, and we see that John Marshall, deciding whether Congress could pass a law establishing a Bank of the United States, he read the document. You know how many times the word bank appears in the Constitution? Anybody know?
No.
Yes, 0 is the right answer. Correct, 0. But he says they still can do it because there are other words. There are more general words that might be read to encompass this, and we should. Why, he says? Because it's a constitution that we are expounding, and it's meant to last for 50, 100 years, 200 years, more than that, to deal with problems that we cannot see at all, he says. Or if we can see them only dimly. And they wrote those words around the basement or the first floor of the Supreme Court. It is a constitution that we are expounding. And you ought to go back and look at McCulloch, because you look at those words alone, you have no idea what you're talking about. You say, well, of course, but read what he has in mind. A workable document as the country has grown from 4 million people to 330 million, every race, every religion, every point of view, etc. And yeah, okay? So look at words, purposes, consequences, values, and your brother put in a few other things, which I will look at from time to time, sometimes the history, sometimes how thoroughly they went into this, sometimes how close it is to their basic mission, sometimes, all kinds of things. So look at them. Now, that's what I think should be done, and the only way I can show people that what I thought. And I imagine what Ruth thought, because we're very rarely on the opposite side, except in copyright. But yeah. Okay. So I say this is I use examples, lots and lots of examples. Why? A good reason, because examples help teach people. A bad reason, because there are 500 law professors in this country minimum who think they know the theories of these things better than me. So I can counter that by saying I'm not talking about theory. I have had some experience you haven't had, and I'm writing from that basis, and I'm writing on the basis of examples. Okay? And that's what I do. But I'm trying to show something. I'm trying to show my belief after 40 years of directions that you might take. It's not original with me. Montaigne wrote, don't write rules, write approaches, write 1584, write standards. Not always. You have a procedural rule. Rules help with procedure. But standards help too. General approaches help too. Norms. All kinds of things there. Yeah, try that. But the tidal wave. What's that? Textualism, originalism. What's that? Well, Nino writes, you know exactly what it is. He says, textualism, read the text, stop. Don't go looking to purposes. Too complicated. Too many different ones. Too many ways of cheating in Congress. Maybe. Don't look at consequences. Don't look at values. Those are just ways of the judge substituting what he believes is good for the law. And I say, no. I mean, no. You've got to look at these other things too. Okay, we debated this together often. Lubbock, Texas. A lot of students in the football stadium. Why? They probably thought we were going to play football. It was Nina and me, and we talked about this, and they came away thinking they're friends, they like each other, all true, and they think very different things. But we talk also about our basic approaches to these things, and I would say, George Washington didn't know about the internet, freedom of speech and so forth, and he would say, I knew that. And he'd say, well, it's different. He said, I think it's the two campers. And what's the two campers? He said, well, the two campers, first one's putting on his running shoes. Second says, why are you putting on your run? He says, a bear in the camp. A bear in the camp? You can't outrun the bear. He says, yeah, but I can outrun you. And he says, that's all I'm trying to do. And I would say, and then he would say, but Stephen, this system that you've just sort of described briefly is so complicated, you're the only one who could do it. Compliment. But not really. But I say, well, yeah, but your approach to these things is going to lead to a constitution no one wants. And that's what I think lies underneath this war here. And we won't know the answer really for years. For years, I'll never know. But that's what's going on. So I say, you make some promises. And he does, explicitly, 4 promises. He says, you follow textualism? Easy. You read the words. You look to see what those words would have meant to a reasonable person at the time they were written. No. It's a fair system, since everybody will reach the same result. Every judge across the country. None more of these splits. And Congress will love it because they know what will happen, and it will rein in those judges who substitute what they think is good for the law. And I think, or say, those promises are great. If I just heard you giving those promises for textualism, I'd say I should be a textualist. But there's a problem. You cannot keep one of them. Not one. What about just looking at the words or, etc.? I say, okay, try a real case. Let's try one. I like one which is the easiest to me. The easiest. Anyone can, who has a handicapped child, ask the school board to give them some special education. If you think the school board is not doing a good enough job, you can bring a lawsuit. If you win that lawsuit, you get your, he says the word, costs. Okay? Question. She said, I want my cost, including the cost, $29,000, of an educational expert. Does that word include educational expert? Or does it just include legal costs or court costs, something like that? So I say, okay, let's try it. Let's try it. We will look at the word cost. Okay, I'm going to look really carefully because it's a tough case. I said, cost. I have the answer. Well, I could try repeating it. Cost. Cost, cost. Cost, cost, cost. I said, that doesn't seem to get me very far. And let's look at why they passed this. Let's look at consequences. We might still disagree, but let's look at these other things. And there are others. That's an easy one. You can sue people in the government all over the place for torts. Not everybody, because there's some exceptions in the statute. One of the exceptions says you can't go sue a customs for certain things. You can't go and sue a customs and excise officer or any other law enforcement officer. Now, who does that mean? Any other law enforcement officer. Does it include the traffic cop? Does it include the 100,000 ordinary policemen? Hey, if it does, we've gutted this exception. We've gutted the statute, not gutted the exception. We built it up. Well, try repeating the words 50 times, same problems. And so you better look to see. And I would look far, perhaps farther than most. I discovered these words were written by Baron Holzhoff, a procedural expert, later a teacher, famous for his treatise, and he was over in the Department of Justice, and he wrote it, and he was trying to copy the English, and the English only customs and excise officer. So I said, well, that's where it came from. Nobody objected. Let's say customs and excise policeman, any other officer related to customs and excise. Yeah, but not everybody agreed on that. I'm trying to show you the kind of thing. So I said, we have no choice. Oh, by the way, you say at least you're reining in? Reining in the the judge who will substitute. You shouldn't do that. You shouldn't substitute what's good for what the law requires. No one thinks you should do that. Somebody might say yes, but they're being sarcastic. But no. All right. I try. Keep it at a distance. You can't totally. I mean, I did grow up in San Francisco. I did go to Lowell High School. I did go to Stanford. Every one of us has had the life he's had. And you say you try to jump out of your skin, you can't. So, of course, that has some influence. But you try to keep it down. All right. Let's look at, do I dare say it? Dobbs. Abortion. Now, Justices Kagan, Sotomayor, and I wrote a long dissent on that together. But one of the points is this. Oh, textualist judge. That's my imaginary. Oh, textualist judge, why did you overrule Roe? Why? Why did you overrule Casey v. Polino? Why? Is it that you overruled them because they did not follow a textualist method? Is that why? I know what he's going to say to that. You're going to say, of course not, don't be ridiculous. That's because if he says the contrary, he's going to overrule every case, because there are very, very few cases that were decided by a textualist method, certainly before the 21st century. He's not going to say that. He's going to say, I overruled them because I thought that they were very, very, very wrong. Wrongly decided. Wrong, wrong, wrong. So all I want to say here at this moment is, oh, I get it. Now I see. What's your job? Judge. Textualist judge. And there's no risk that you will substitute what you think is good or bad for the law when you're deciding how wrong something is? No risk there, but there is a risk when I decide how I decide a case. I say, how does that work? I haven't been able to figure that one out yet. Seems to me like a contradiction. And so if that is a contradiction, which I think it is, they have just as big a problem. And if they have just as big a problem, there they go, the four promises. Bing, 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 down. So I say the promises don't work. You can't carry them out. You cannot carry out those promises. So where's the plus? And I see a lot of minus. And the minus is when we get something very different from what Congress wanted or what the founders wanted or what the basic values are underlying this, and it detracts from some extent from a basic object of law, as I did learn from Hart and Sachs at Harvard. Some basic object that law in general, not always, but in general should work in a way that helps those 330 million people live together peacefully and productively. Okay? And if that goes too far or too fast or both, people will have less reason to follow a rule of law. For the rule of law depends not on judges or lawyers, it depends on people who are neither, and contrary to popular belief, 299 million of America's 300 million are not judges. Yeah, hard to get people to believe that, but it's true. And they're the ones that have to follow case decisions that they don't like. And they may be right. You see, that's called rule of law. So I see a danger. I see a risk of reaching wrong results. I see a failure to carry out the promises. And that is, now you don't have to read the book. You can still buy it, but there we are.
So we have time for one more question on my end, and then we will open up the floor to audience questions. So get your questions ready. The last question I want to ask you about was the final pillar of the Katzman Initiative, which is civic education. You have spoken today and throughout your career written movingly about the judiciary's role in public life. You have written about the openness of courts to the public, the Supreme Court to the public, in fact. And these thoughts, a Katzman Initiative board member reminded me, are similar to Judge Katzmann's initiative in his circuit entitled Courts and Community. So general question first, do you think the judiciary as an institution should have some role in the creation of a civic-minded public. And what might that role look like?
Sure. I mean, that's what I told my friend who came in to see me from the Prime Minister, the Chief Justice of Ghana. And she asked a lot of questions. She wants a more human rights-oriented system. But the big question was, well, why do people do what you say? I mean, it depends upon, Andrew Jackson refused to do what the court said and kicked all the Indians out of northern Georgia after the court had said he couldn't. He just did it. He brought in the 4 troops, and they walked on the Trail of Tears down to Oklahoma, where the descendants live to this day. And sure, how do we stop that? I said, that's a good question. I had to tell her about that case, but I told her about Cooper versus Aaron. And Governor Falbus saying when those 9 black children tried to enter that white school, said, well, maybe they have a court order, but I have the state militia. And telling Eisenhower that he was going to let them in, the black kids in the white school. He told the press the opposite. Eisenhower's pretty angry. Right. Sends in 101st Airborne from Fort Bragg, the heroes of World War II. Normandy, it's coming up this weekend, invasion, 80th. Everyone knew who they were. And they take the kids in, but they couldn't stay forever, so it doesn't have an immediately happy ending. Eventually they have to leave, and Faubus closes all the schools, closes the school. And then Cooper Aaron comes to the Supreme Court, and the court says, integrate. But he closed the schools. But I say it's too late. That's the era of Martin Luther King. It's the era of Rosa Parks. It's the era of the Freedom Riders. The North had awakened to the problem in the South, and they couldn't get away with it. Not just because of the court, but because the opinion in the country would overcome the black efforts of resistance, which only took, the South's efforts of resistance to the black integration, which only took about 10 years, if more, not more. You see, I have to explain all that to her. And say that's a long and difficult effort to explain to people and get them on your side, to accept things they actually don't agree with. And that's really at the bottom of a rule of law. All right, that's a complicated thought. A complicated thought. And people aren't going to understand the relation of that thought and other complicated thoughts to the life they're living in this United States of America, unless they're taught that. And so I say to her, get the judges to explain to the newspaper editorial boards, or at least the lawyers, or have the lawyers go out. And you don't have to convince them. They make their living out of it. And but have them explain in the villages, in the towns, in the people, the 299 million who aren't, lawyers or judges. Explain it, explain it, explain it. And I think that's one of the best initiatives that Bob had, that initiative of bringing school kids into the Second Circuit. The same thing is true in the First Circuit. We'll do the same thing there. Bring them in and let them play judge. Great. They see what's happening. And of course that's important. And I can't think of a better institution to do it because you preserve a lot of arguments and don't do them. Don't get into them necessarily if you're being a judge and managing a judicial system. Explain to them. Have them participate. Let them see some cases. Let them see how that judicial system works. And it's like jurors coming in. Jurors come in, they don't want to do it. They're sorry they have to, but they don't go away that way. They go away thinking this is a very interesting, not such a bad system, when 12 people chosen at random have to reach agreement before a person's liberty or much of his property is taken away by the government. So of course the judges and others can do it too. Nothing wrong with a senator, congressman having a television program directed right at his high school in his district and showing him what he does every day.
Thank you. Let's hear from the audience. I think there were some microphones circulating. I think Bill Eskridge.
Yes, thank you. I'm Bill Eskridge of Yale. Thank you very much, Justice Breyer, for your fabulous remarks and the pay-on to Katzmann. I might add the costs decision was a Katzmann decision that was reversed by your court with you in dissent. I want to ask a question from your grandchildren's perspective. So I think you hit the nail with your head that the textualists cannot, and they know they cannot, fulfill any of the promises. And in fact, the Katzmann opinion documents in the cost case that they were ignoring statutory language that went against them. In other words, they gerrymandered the text in addition to all the other criticisms that you make. But here's the problem, and this is one your grandchildren will understand. They're the future. And that is that when you explain textualism, they're in the closet. Krishna Kumar and Norris have documented. They look at consequences all the time. They did in that case. But they deny it. They're in the closet about consequences. They're in the closet about complexity. And they say, look, your grandchildren are only going to listen to a pitch for about 60 seconds. Text, whole text, nothing but text, 6 words, you've got our theory. And then you got Breyer. Well, you know, you look at this and you look at that and so on and so forth, and then you have to consider this and da-da-da. You can't do that in 60 seconds. And so to a certain extent, the success of textualism is a success of the closet. They have a very simple sort of mantra. They repeat it over and over again. They deny departing from it, and then they accuse you of sort of complexifying things so much that judges are going to be misled, right? And judges are going to be turned loose to impose values. Whereas they can do it through, like Bostock, the Title VII case, you were on that, textualist war. And they all looked at consequences, except kind of the decision you joined. But the rest of them, the textualists looked at consequences. Scalia often looked at consequences. Sweet Home, the Spotted Owl case, you were on the majority, Scalia was in dissent. And his first line of the dissent was, this is a socialistic war on the simplest farmer whose land is being expropriated for national zoological use. That's a normative appeal, and they did that all the time. But he claimed just to be doing text. So this is kind of like a grandkids postmodern question. For the generation that gets their news in 60-second YouTube bites, what is the strategy for opposing textualism? What is the educational process to supplement the speeches to high school groups, but the strategy in this internet era, this YouTube era, et cetera, et cetera?
It's a good question. What I'm reminded of is, it's a little far-fetched, but I read in the Globe Spotlight team once that they found what do you call it, a no-show job that this guy had obtained through Senator Kennedy, I think. And they confronted him and they said, you didn't show up at your job once last week. And he said, I work at night. You forget. They said, we followed you at night too. And for 4 nights, you went around giving speeches to elect Senator Kennedy. So when did you do your work? And he said, you forget. I said, what do we forget now? He said, there are many hours in the night. Yeah, there are many ways. There are many ways. You teach classes. They sit there and listen. They're going to be out of the law school. They listen. There are Sandra O'Connor and her civics, civics. Pictures. Pictures work with iCivics. There are lots of teachers. There are lots of lawyers. And there are judges themselves who, after time, don't want to sit there and make up things when they don't work. Why? Why do it? If you're doing it so some group of people who worries about judges continuously applaud you, first remember they won't. There will be plenty of times when they don't, and you're a terrible traitor. And what's the pleasure of that? Diminishes rapidly. The pleasure that grows is the pleasure of trying to do your job properly as best you can. And I think when human beings were there a long time, how long was Charlie Wyzanski there? About 50 years. Yeah. They see this isn't working very well. Nino, remember, is a kind of pioneer in this. So pioneers are always somewhat, perhaps, overstating and saying something. And he was a great writer. And we used to, at our joint things, people would very often say, why do you say mean things about your colleagues and your opinions? Aimed at Nino. So I'd say, I'm going to answer that question, though I know perhaps it's not aimed at me. And the reason is because some of us suffer from a disease. And the disease is called good writer's disease. And when a good writer finds a felicitous phrase, can't give it up. The earth may come to an end. And I say, we all understand that in his writing, and it doesn't bother us. You see? So there'll be many, people that get paid down in Silicon Valley. My God, we were just in California. My son now, his family is near Silicon Valley. I mean, it's very beautiful. The weather is fabulous. But I saw Lawrence Ferlinghetti, who was one of the beat poets of my generation, asked, "Do you like San Francisco now?" "No." "Why not?" He says, "Too many techies." "What's wrong with that?" He said, "They have too much money." Yeah, you see that. "And they raise the price of everything." "Oh, my God." "And they have terrible manners." He said, "Well, I don't know about that. But the prices are unbelievable." But those people get those unbelievable prices and salaries, I guess, because they can invent things that will take what you want to do, and they will put it to those grandchildren on those screens in a way. And I thought one thing we could do, which I'd like to do if we could, in this 250th year, a couple of years from now, is let's get the general counsels of Facebook, of now it's called X. See, I say X and they automatically.
They're listening.
Yeah, get them. And you saw this movie, Social, what's it called? Social Dilemma? Ah, yes. Everything you say doubled. My God. Building habits to see the Martian tentacles come in and choke whatever they choke, I don't know. But hey, let's get them to form the habits to watch civics. Let's get them to form the habits to watch this congressman who's going to tell the high school what he does. I mean, there's a lot you can do, I believe. And so I'm not totally pessimistic. And nobody's pessimistic about his grandchildren. When I speak to the college, I say, hey, I hope your grandparents are here. Why? You want to know why? Just because your grandparents are the only people in this world who know for absolute certainty that you are perfect.
We have a time for two more. Yep. And if you could let us know your name, that'd be great.
Hi, thank you. My name is Kemi Oshukoya from the Africa Bazaar magazine. I'm glad you mentioned Ghana. My question to you, you mentioned your grandkids. And I know you don't want to comment on current situation, political issue. So as you look at the country and you look at the world, what keeps you awake at night? And I'm not talking about coffee. And the other part of my question to you is, you've spent years at the Supreme Court. Could you share one of the most challenging cases that you work on?
Well, two opposite things. Okay. The first question, look, you have to understand my personal history. This is my father's watch. And by the way, Ketanji's in the same situation. He was lawyer for the school board at San Francisco. It says Irving Breyer, San Francisco Unified School District, 1933 to 1973. And yeah, that's how I grew up. And he used to say that if you want to be a lawyer for the school board, and I told Ketanji this, but her father said something similar, you have to know the answer to a geography question. And what's that? Where is City Hall? Yeah, that's right. So I naturally gravitate towards what are we teaching. And the thing that worries me is we won't teach. Yes, they say in the 3rd grade, George Washington chopped down a cherry tree. Probably that's not true, but teach it. Say something. And there's a value in this. And these mythical stories are part of the mythical base that establishes what's in this document and which establishes how 330 million people live together. So teach the good as well as the bad. Teach how this came about. Teach, this is Squattaguatsa, 4 kids, same grade, okay? Find out ways in the schools to teach them together, to work together, and remind them. Maybe they could even read this. That's possible. And what worries me is we get so caught up in current issues, which are that's legitimate to mention current issues, of course. But there's more. There's more. And I read in some magazine somewhere that some countries are based upon history, which has some good things to it, but not such good things if you're worried about who won the battle of 1215, and that's still bothering you. All right. Other countries are based upon documents. There we are. And whichever it's based on, that's the thing that has to get through. And what worries me is maybe it won't. Everybody trying to be too rigid or whatever. Anyway, that's the thing probably worries me the most. Teach them, we'll get somewhere. Okay, the other question you said is, what's the case? Well, it's hard to say because, of course, Dobbs worried me a lot. Of course I thought that. But the case that I found the hardest, you're not going to even have heard of this case. But what I found the hardest case, but in a way was one of the more valuable, was a case called Google versus Oracle. And that was oh my God. You see, it was about copyright protection of certain parts of a program in the Java language. And when we started out, I thought Java was some kind of island somewhere. And I had no idea. But we took 2 sets of law clerks, 2 years, and a lot of work before we got to an answer in that case. And the reason I was sort of pleased with it is I don't normally look to what the lawyers who are experts say about a case that I've written, because I know that ones who won think it's great and the ones who listen, usually I miss. But I looked this time because all I wanted to see is, did we get roughly the background right? And they thought we did. And okay, so to me, it shows, I mean, the court isn't all about abortion. Unfortunately, I wasn't happy about that case, but, you know, but it's about a lot of things. It's about a lot of things. And before everybody gets too excited out at Stanford, when I said even Bush v. Gore, which I dissented in, and you're all upset, I heard Senator Reid say the most remarkable thing about that case is never remarked, that people didn't throw stones in the streets, that they didn't shoot each other, that they didn't have bonfires and riots. And I say to the Stanford students, and I know a third of you minimum are thinking, too bad there weren't a few riots. Too bad there weren't a few stones. But I say, before you come to that conclusion, go and turn on the television set and look and see what happens in countries that decide their major decisions that way. So these are basics. And what I want, I fear most, what I want is just that taught in enough depth so that people understand the history, the good and the bad. And what I fear, maybe they won't. Maybe they won't. I clerk there.
Wait. Oh, yes. Oh, excellent. David.
And then her. You should get her.
Perfect.
I'm David Lauk, also a former Katzmann clerk, and like Brian, also former clerk to the Justice, actually the term of Google v. Oracle. And on the theme of technology, I was wondering if you could talk a little bit about your thoughts about the role of technology in interpreting the Constitution and statutes. And in particular, it strikes me that it's easier today to look at the history of the ratification of the Bill of Rights across the states at the time of the founding to look at the original, public meaning than it was 50 or 100 years ago. And now with statutory interpretation, we have judges who are interested in using corpus linguistics and large language models to see how patterns of usage occur across large bodies of text. Again, something we couldn't do 50 or 100 years ago. So I'm wondering what role, if any, you think technology does or should play in how we employ tools of judging over time?
Well,
Thank you.
You know that because it was my law clerk. I mean, of course, I will want to know what people thought this meant at the time. That's a relevant factor. But beware of putting too much weight on that, among other reasons, which we wrote in Dobbs, the three of us, among other reasons for beware of putting too much weight on some things some of the time, is it's important to remember that half of the United States, perhaps a little more than half, was not represented in the political process at the time these things were written. And that's relevant sometimes. And slaves too, women and slaves are not, of course. And go back and see what it meant at the time. Yeah, do it if you want to do it. I think, and we wrote in Bruin, judges are not historians. And where you say we're just going to look and see what weapons were protected at the time, and if they were protected at the time, they're protected now. And we include in were they, the they includes sort of, what's the word, analogous weapons. I like this. You wouldn't let me probably say all the things I wanted to say. We looked up in Wikipedia what were some of the weapons used in the 100 Years' War. So I put in, and what is a lineal descendant of, for example, a skill ladder or a halberd? Or Asian fire, which you used to throw over the wall or something. I mean, is that the part of artillery? I mean, can you set somebody else's house on fire? I don't know, and nor does anybody else. All right, so be careful. And we did have in the by the time we got to Bruin, we had some group of historians who had looked up. They said, we found 200,000 examples of the use between 1760 and 1790 or something like that of the words right to bear arms. And virtually everyone, that's the Second Amendment, and virtually every one of those had to do with militia. So I said, maybe we should overrule. But so we're not experts. Beware of that too. And remember the words engraved around. It is a constitution we are expounding for satisfactory resolution of problems we do not know and can only dimly see at best. Okay? That's there. And if you say, hey, that's so vague and difficult, so many things we don't know, then I say to that, well, law is not computer science. Law is not physics. And I didn't make that up. Go read On Experience 1584, Montaigne. He says Justinian was an idiot trying to reduce all of the law to a set of rule-making codes. He says, doesn't he understand that every word in a code is simply an excuse for lawyers to make an argument? He says, doesn't he understand that life is complicated? Life is vague. Life has all kinds of ups and downs and life will exceed any kind of code that you write in ways that you will not be able even to guess. That's not me, that's him. But that's been true since Justinian anyway, and probably before. I just read in some review that people have been around not for 50 or 100,000 years, but 1,000,000 years. Well, I don't know what it was like 1,000,000 years ago. Maybe they had textualism. But regardless, that's true of life, and this document is written for life, and therefore I admit to a degree of uncertainty. I used to think a sort of a mess up there, and we get a case, and we try to make a little bit of clarity, and before you know it, it's a mess again. All right, but that's our human situation, and judges are part of that, and they have a role, and I think textualism is minimal in that role.
On that note, I think we need to wrap up. If you all would join me in thanking Justice Breyer for his time.